My name is Richard Stevens. For those of you who don't know me, I was for 40 years a solicitor. I worked mostly, almost exclusively in the technology sector. I've seen the industry from all sides. I have been an in-house lawyer. I have been a solicitor. I have done litigation. I've done non-contentious work. I've looked at it from all sides. I shut down my firm at the end of 2023. And I divide my time. I'm still doing some sort of solicitor work for some clients, but I divide my time now mostly between providing commercial law training, mostly to law firms, but to others as well. And I also work as a mediator or arbitrator in commercial disputes. So that's enough of me. I'm going to be talking about loss of profits. So without further ado, I guarantee this won't take any more than 20 minutes of your time. Without further ado, I'm going to share my screen with you and we will kick off. So your 20 minutes starts now. And I've called this one loss of profits under the spotlight. I could have called it the exclusion of loss of profits under threat because there have been so many cases on it recently. I provide, as many of you out there know, I provide an annual update on contract law. I also provide an online quarterly update on contract law. And I've covered all of these cases in the last few years, all of them dealing with this exclusion of loss of profits. Recently, a case has gone to the Court of Appeal. It's the second time in recent years that the Court of Appeal has had to look at an exclusion of loss of profits. And it's that case I want to look at today. If you've been looking at a liabilities clause this morning, for example, you might like to get that out and have it open on the desktop, because in 20 minutes, you're probably going to want to revise it. The case I'm going to be talking about is EE and Virgin Mobile. It's the third up from the bottom there. That was the first instance reference to it. It doesn't have a hyperlink because it's still, as far as I know, checking yesterday, it's still not on Bailey, and it's not on the government's National Archive Service either. It was purely by luck that I came across it, but it has now gone to the Court of Appeal. And in the Court of Appeal, the Court of Appeal looked at a whole load of other cases too concerning loss of profit. The top three, those first three there, I've also had occasion to report on as part of my contract updating sessions. And the others besides were looked at in some length by the Court of Appeal. Loss of profits exclusion under the spotlight indeed, and possibly under threat. The quotable quote I want to give you is this. In one of those cases, the judge said this: there are few, if any, losses suffered by a commercial concern that could not be described as amounting to or producing a reduction in the profits or loss of profit in this very general sense. So that must be true. When you are writing that bog standard common garden exclusion of loss of profits, you are in a sense trying to exclude the most likely form of loss that a commercial venture is going to suffer. Of course they are. That's why they go into a commercial venture, to make a profit. You don't go into it expressly to make a loss in the overwhelming majority of cases. So with that by way of background, let's have a look at this case in the Court of Appeal. EE and Virgin Mobile Telecoms. EE, one of the big four network operators in the UK, and they provided networking services to Virgin Mobile. Virgin Mobile paid EE charges based on the usage made of EE's network by Virgin Mobile's customers. There were two other provisions. One was an exclusivity provision. Virgin Mobile couldn't, for the period set out in the agreement, shop around for a better deal. It had to send its customers to EE's network, so that EE would earn charges from those usage made by those customers. There was also a minimum revenue commitment contained in the agreement. And it was common ground that, that Virgin Mobile had always exceeded that minimum revenue commitment. Technology changes. 5G was on the horizon, so the parties agreed an amendment. And they said that they might come to terms, commercial terms, on including 5G in the TSA, the Telecommunications Supply Agreement. They contemplated that they might not be able to come to terms. And in that case, it was specifically allowed to Virgin Mobile to go out and enter into a contract for 5G with a different network operator. The exclusivity provisions were to that extent waived. And that's exactly what happened. They couldn't come to terms, and so Virgin Mobile went out and entered into a contract for 5G with Vodafone. The allegation in the case was that Virgin Mobile had diverted customers away from EE to other network operators outside of the permission given in respect of 5G. EE was claiming a shade under £25 million. And they said, I set out the description there quoted in the judgment. Basically what they were saying was, you have breached the exclusivity provisions, you've diverted customers away from us, and the charges we would have made from those customers amounts to just under £25 million. You could describe it as the charges foregone, the revenue foregone. Okay. Virgin Mobile turned round with the contract and they said, presumably with a smug smile on their face, they said, well, have a look at this. It says here, neither party shall have liabilities to the other in respect of anticipated profits. And what you're suing for, you're dressing it up. It's window dressing. You're calling it revenue foregone. But really what you're claiming is your anticipated profits. And that's not allowed under the terms of the agreement. Now, when I talked about the first instance decision, I took it very simply. And I said, and I just quoted these words, to keep it simple, we like the low-hanging fruit. I could have added in a bit more to do with this clause. Anticipated profits, anticipated savings, those two are stablemates and they very often appear in the same exclusion. But there are still three little dots there at the beginning. So let's have a look at the whole clause. Except for any damages claims made by Virgin Mobile pursuant to clause 34.2 little c, to which clause 34.3 applies, which EE acknowledges may include claims of damages for loss of profits, and for no other damages claims whatsoever. And then it goes on with the exclusion that I've just described. So there is a carve-out in which Virgin Mobile can make a claim for loss of profits. And it's set out there, 34.2 little c and 34.3. So the eye eagerly goes to the rest of clause 34. Now, the first subclause sets out a cap that's applicable to both parties. We may come back to that in a minute. It then goes through to 34.2 little c. That cap will not apply to any liability for damage or loss arising from reckless or willful misconduct or gross negligence. Now, for those of you out there who know me, you will know my thoughts on the use of the expression willful misconduct, and you should already know that there's no such thing in English law as gross negligence. I will park those issues. I will not allow myself to be diverted into talking about them. But the important thing is there's a carve-out from the cap for reckless, willful misconduct or gross negligence. 34.3 goes on to specify that willful misconduct would most specifically include EE intentionally discontinuing service to Virgin Mobile. And that's the case when Virgin Mobile can sue EE and it will not be bound by the exclusion of loss of profits. The clause went on, fairly standard exclusion of liability for indirect or consequential loss. And of course, then at that stage, we went into 34.5, which is the exclusion of anticipated profits, anticipated savings. So it's quite a complex sort of regime for liability. And it's just worthwhile summarizing it. It opens with a cap that's pegged to a percentage of annual spend, basically. We'll come back to that in a minute. It then goes on to the carve-out. The caps don't apply for reckless, willful misconduct or gross negligence. We then specify that willful misconduct by EE would include intentionally disconnecting service from Virgin Mobile. And then we go on with a fairly bog standard common or garden exclusion of indirect consequential loss. And we've seen fairly bog standard common or garden exclusion of anticipated profits, anticipated savings, but with a carve out that Virgin Mobile can sue for loss of profits in that 34.3 instance. Now, as a plot spoiler, the trial judge said that Virgin Mobile could indeed hide behind the exclusion of loss of profits to defeat the claim by EE. And in the Court of Appeal, as a further plot spoiler, they won again, but by the skin of their teeth. 2-1. Lord Justice Phillips, in a remarkably short dissenting judgment, said, "In my judgment, it would be surprising if the parties intended that Virgin Mobile could breach the key exclusivity provision, unlawfully diverting its customers to a third-party supplier without incurring liability to pay EE damages, reflecting the loss of revenue resulting from that breach." That was his view. The other two, Lord Justice Zaccaroli gave a very long, case-heavy analysis of the situation and of EE's arguments, but decided that the trial judge was right, that Virgin Mobile could hide behind the exclusion of anticipated profits. The other judge, Lord Justice Coulson, said he agreed with that reluctantly. And his first impression was that he was going to side with Lord Justice Phillips. So when I say it was a majority of 2-1 in the Court of Appeal, it's more like it was a majority of 1.5-1. Virgin Mobile certainly won, but they won by the skin of their teeth. As I say, loss of profits exclusion under threat. What did the Court of Appeal therefore say? And we're interested in the long judgment of Lord Justice Zaccaroli. Well, you have to look at the substance of the claim. And all those cases I gave you at the beginning of this session, they were all about parties who were trying to recharacterize their claim. So it's not loss of profits. In this case, we saw it was recharacterized as revenue foregone, charges not made. The court said you can't do that. You can't just relabel your claim to get around a loss of profits exclusion. If at law it's basically a claim for loss of profits, then it will fall foul of the loss of profits exclusion, possibly. One size fits all. The exclusion, if you put an exclusion of loss of profits in there, it will apply to all breaches. You don't have different constructions of loss of profits for different types of claim. So you have the same construction given to an exclusion of loss of profits, regardless of whether it's something foundational like the exclusivity provision or something completely trivial. It's the same construction you have to give to it. But there's no law on this, no law at all. As Coulson LJ said, as to the law, it's not unfair to describe the cases relied on by EE as something of a ragbag of particular results in particular types of cases. Loss of profit, anticipated profit, it's not a term of art. There's no legal definition as such, and it can take on different meanings in different contexts. And in the case law looked at by the Court of Appeal, you can see that typical exclusions of loss of profits can be got around by the courts in appropriate circumstances. The Kudos case is a very good example of that recently in the Court of Appeal. In this case, however, they said the words were clear and unequivocal, and they referred simply to the profits that were anticipated at the time of the breach, and so it meant the same effectively as lost profits. And it therefore meant expectation as opposed to reliance losses. So here you have damages, construction law coming up hard against academic law. And they said, look, in a lengthy contract like this, professionally drafted legal advice on both parties' sides, we can't go behind the clear, unequivocal words used by the parties. Is that necessarily true? This is what the judges thought of the TSA itself. The judge, trial judge, Joanna Smith J., she said it was a bespoke, lengthy, detailed contract, detailed consideration of going to the risks and rewards of each party. Clause 34 itself was a detailed regime, including a liability cap, various exclusions, clearly intended to form part of the risk allocation exercise between the parties. In the Court of Appeal, they said the clause was part of a lengthy contract drafted with the assistance of legal advice on both sides, involving a careful allocation of risk for both parties. Well, call me Mr. Cynical if you like, I'm not sure that's necessarily true. Let's have a look at the cap in this case. Neither party, it said, shall be liable to the other under this agreement to the extent that the aggregate liability of that party in any annual period would exceed 15% of the total spend payable or payable, paid or payable by Virgin Mobile in the 12-month period preceding the event giving rise to liability. Now you have here that horrible mismatch between an aggregate, in this case, an annual aggregate liability, but it's pegged to 12 months prior to an individual event. And we've seen several cases on that recently where the courts have struggled with trying to give any sensible, coherent meaning to that sort of drafting. For the rest of the clause, it had pretty much bog standard common or garden exclusions of liability for indirect consequential loss and anticipated profits, anticipated savings. I didn't see much novelty there. The only thing that was novel, in a sense, was this carve out in favor of Virgin Mobile so that it could sue for loss of profits in the case of intentional discontinuance of service by EE, which is a pretty obscure circumstance, I would have thought. But that's the only thing that I could see that was original. Call me Mr. Jaded if you like. I think this looked pretty template drafting for the most part. So the thought I want to leave you with is this. If one size fits all, you need to try some original thinking. The big argument about loss of profits and the big justification for it, as recognized by the Court of Appeal in the Soteria case, is that loss of profits is purely hypothetical in most cases. But as EE said in this case, the charges foregone weren't hypothetical at all. The contract was very long and very detailed. And so if you could prove that Virgin Mobile had diverted 10,000 customers, say, to different network operators, EE said, well, we could work out to a nicety exactly what those charges would be. And there's nothing hypothetical about that at all. We know exactly what they would have had to pay us in respect of those 10,000 customers. I think this case is a clarion call against the template approach to drafting. And for those of you out there who know me, you know one of my favorite stories is that when I started out as a lawyer in the IT industry, as an in-house lawyer, in what was then a completely new industry, we had no templates. I had to write out many contracts when I was drafting them in longhand on bits of paper because laptops didn't exist. We didn't have laptops because we had things called secretaries, and they sat behind computers that were huge beige boxes, and they had to make head or tail of my scrawly handwriting and write it all and type it all out. And I had to go through it all page by page, checking for typos, lines or words missed out. I had to go through it several times, but it meant that nothing I did was truly bespoke. Everything had thought behind it, and in my view, it was the better for it. I think in this case, they put together a liabilities provision. It wasn't detailed. I don't suppose they sat down with their clients and angsted over every last word of it. There was clearly some novelty for the carve out in favor of Virgin Mobile, but for the rest, it looked pretty bog standard. And the thought I want to leave you with is this. Is that the right approach to a loss of profits exclusion going forwards? Because you need to sit down and work out exactly what the loss of profits actually is, and whether that's really what you want to apply to all possible breaches of the contract, from something trivial up to something foundational like the exclusivity provision. Believe it or not, it takes longer to put together a short talk than it does a long talk, because I have to keep watching the time all the time as I'm preparing. So if you liked what you heard today, then please feel free to buy me a coffee. And if you want to ask any questions, you may. You can even get in touch with me. There's my email. I'm very happy to take any questions if you're too shy to raise a question now. Other than that, I will draw things to a conclusion. You are free to go.